Looking at who's here, I hardly need to introduce Christian, but I will anyway, because there are a few students who may not know who he is. Christian Twigg-Flesner is he's Professor of International Commercial Law at the University of Warwick, and before that he was at the University of Hull. And he works in commercial, consumer and contract law. That's what he teaches and that's where he works. And he's particularly looking at the implications of digitalisation, which is something that we're all having to struggle with one way or another. But he's going to look today at a very particular area, which is 3D printing, and thinking about the ramifications for the Sale of Goods Act and contracts of sale of goods for 3D, the ramifications of 3D printing for that. So I think I'll hand over to Christian now. I think I need to say anything more. Christian, do you have slides to share? And can you do that?
I do indeed, and here they are. Look what I practiced earlier, it works. Thank you very much indeed, Louise. Thank you for having me, albeit virtually this time, and thanks to everyone for coming along. What I'd like to talk about in this talk is an issue that's really been something I've been keeping an eye on for many years. In fact, this was my way into the whole area of digitalization and contract and consumer law. And what I want to focus on in my talk today is on the implications of one particular digital technology, 3D printing, on our good old-fashioned contract of sale. And I am going to explore this idea that the effect of 3D printing is to effectively unbundle the contract of sale, to turn it from a straightforward transaction into one that's broken down into various components, and which will inevitably raise some interesting and potentially novel questions. Although, to give away the ending, I suspect that when it comes to 3D printing, the real impact is not going to be as significant as many other aspects of digitalization. So, hang on a minute, there we are. So let me start by saying a few words about the technology first, before I then turn to the legal questions, which I think are particularly relevant from a sale of goods perspective. 3D printing has actually been around for quite a long time as a technology. It's far more advanced and established than, for example, blockchain technology or indeed the growth of AI that we have seen in recent years, and that continues apace. 3D printing is better known as a form of additive manufacturing or additive layer manufacturing. And the idea of 3D printing is that physical items are produced not by using something like injection molding, which is often used for mass production still, or by taking a block of something, a block of wood or a block of stone and chipping away at it, but instead by building up these items layer by layer, and these layers are incredibly thin. And in order to support this process of building up an item layer by layer, a number of different types of technology can be used. One that's very widely used, and possibly also one or two of you at home, I might have it on your desktop, I suppose, is something called thermoplastic extrusion. And this is effectively adapting the old-fashioned inkjet technology for the creation of three-dimensional items. And it works by having a nozzle where a little bit of liquid material is extruded through the nozzle onto a surface, and then the surface is lowered ever so slightly, and the next layer of material is extruded on top of what has already been put on the surface, and so on. For more advanced printing, there's something called photopolymerization, where a laser is used to selectively solidify elements within a liquid base, quite an interesting technology, and also something called granular materials binding, where we have a large vat of powder, and then through various technologies, the powder is formed into solid shapes. Now, each technology has particular features and particular advantages and disadvantages. Thermoplastic extrusion is very useful for small scale printing, desktop printing, but it has the drawback that it can't deal with so-called overhanging parts. So, for example, if you have a more complex object with bits sticking out, you might have to build a small skeleton as you are printing, and the skeleton then has to be removed. When it comes to, say, granular materials binding, you simply rely on the powder that is not absorbed into the finished item to provide the necessary support. And here's just a tiny picture of a thermoplastic extrusion printer. 3D printing is sometimes referred to as one of the many disruptive technologies because it can have an impact on the way business in particular might operate. And one potential change that has been envisaged is that it may lead to a shift away from centralized production and global shipping to a return to more regionalized or indeed local production of items, particularly where they are not required in high volumes at once, but can be gradually and continuously produced. I'll say more on this in a moment. What are the possible uses for 3D printing? Initially, of course, the great benefit was that products could be customized to the customer's demand. They could also be used to produce one-offs of items, particularly where it simply made no sense from an economic point of view to produce things on a mass scale, or where it simply would be impractical. So there are examples where, for example, the Navy is using 3D printing on board its vessels to make spare parts where they're required. I think the International Space Station also relies on 3D printing. And indeed, 3D printing is being used to make parts that are custom fitted to deal with particular needs of a particular, in a particular context. For example, spare parts or replacement parts for one particular type of vessel or of an aircraft or similar. It has the advantage of allowing for localized production. If you have a printer and you have the necessary material, you can produce a finished item. You don't have to send away for it. You can do it in a localized facility. And it could be particularly interesting on the basis that you can not only print item in 3D, but you can also scan existing items and then copy them effectively by printing them again, leaving aside the potential intellectual property implications. I think there's certainly a likely use case for the creation of spare parts using 3D printing, particularly where it might not be economical to keep a stock of spare parts, but instead it might be worthwhile to print them on demand, and indeed to create spare parts where they weren't necessarily available until now, because you can simply scan a part, maybe work out where a repair is needed, and then you print the repaired, if you like, item or part to be used. It can also be used for tailored tool making. It's been used, for instance, for the process of aircraft maintenance. KLM is one example where an airline is using 3D printing, in fact, to recycle its plastic bottles from its in-flight service when it creates parts for aircraft maintenance. Okay, so how does it work? How does 3D printing work, and why does it raise interesting questions? And indeed, why do we get to unbundling? There are effectively three main ingredients to 3D printing. The first is a design file, a computer-aided design file, a CAD file. And this file contains the design of the item, which will then be printed as a physical item. And this design can be created on a computer, it can be modified on a computer, and indeed it can be shared, it can be tested, and so on. So the CAD file is one important ingredient. The second ingredient is the printer, the hardware that turns the digital design into a physical item. And there are two main categories of printers. There are many large-scale commercial or industrial printers, and they are often as large as a room or even larger than that. Some of you may have seen the stories from, I think, the Netherlands and also more recently the United States, where we have effectively warehouse-size 3D printers able to print concrete building blocks for housing. And there's an entire housing estate now in the Netherlands and also in the US built from 3D printed concrete blocks. But we can also see desktop printers where people actually have small 3D printers at home, whether it is to create little things, as in the picture I've put on the screen there for you, little models of things, or you can do your own Lego figures or your own World of Warcraft figures or whatever people do these days, you can use printers for that purpose. And they are not that expensive these days. In fact, one of the two main German discount stores was selling 3D printers not so long ago at quite a reasonable price. That said, the quality of the printed items is a bit variable, to say the least. In terms of material, plastic is the obvious one that's been used, various types of plastic, but it's also possible to print in a variety of different materials, metal, glass, and so on. And that is why 3D printing is getting increasingly popular. Also, the technology has advanced to make larger volume production more attractive and more possible. It is no longer limited to one-offs or individualized production. You can have a reasonable production run, not quite the same way as you would with injection molding, of course. Now, in order to show where 3D printing starts to change things, let me try and explain 4 common situations where 3D printing has already been used or is likely to be used. And there are a number of different levels, if you like, of deploying 3D printing. Let's take the simple situation first to get us started. Normally, when you have a contract for the sale of goods between a customer and a trader and the seller, the customer simply agrees to buy the finished item, and then the trader will source it from somewhere. And it may be that we're talking about standard goods which happen to have been made using 3D printing, or there might be goods which were customized to the customer's requirements, again, using 3D printing. This situation raises no particular questions as far as the final contract of sale is concerned, because it's still for a finished item. There's no real significance here, apart from the fact that 3D printing may have been used in the manufacturing process. But things might get interesting once the customer, the end user, can interject themselves into the production process. One way of doing this is where the customer has created their own design file. They might be able to use CAD software. They might use scan and CAD software where they scan something and then edit the design online. So they can create their own CAD file. They can then go and print this on their own printer, which is the kind of thing you would probably see when somebody uses 3D printing at home, or they can take it to a third-party 3D printing service. And there are quite a few of these kinds of businesses springing up everywhere. In fact, there is one in my local hometown of Kenilworth, as I discovered some time ago. The end result is still a finished item, but as you can see, it is no longer a straightforward acquisition of a finished item. It involves, to some extent, the customer getting more actively involved in the process. But again, this is still not particularly revolutionary because we have seen comparable instances in the non-digital world in the past. But it starts to show how we can break down the production process into different stages, how we can unbundle the transactions leading to a contract of sale. As we are talking about the digital context, we obviously have to refer to the platform economy, which is a characteristic feature of the digital economy. And here 3D printing has created its own types of online platform. The first type is a simple sharing site where people who have designed CAD files, have designed products and created CAD files can share those. Some of those sites are open access. They're basically freeware. People can just download design files for free. They can play around with them. They can edit them and re-upload them. They're basically shared widely and freely. There could also be for economic purposes. So people might have a sharing site where you have to buy a design file. And then the customer may either 3D print the item themselves on their home printer, or they may again take it to a 3D printing service. End result, of course, is that a finished item is delivered to the customer. Alternatively, there could be an integrated platform which offers basically not only the sharing function, but also allows designs to be even created there, arranges for the printing of any products on demand, and even carries out the e-commerce side of things, basically by processing payments, doing the necessary delivery arrangements, and so on. And again, a finished item goes to a customer. One of the big platforms in this field is a platform called Shapeways, which does a lot of this stuff. And then we have perhaps a situation which is going to be particularly interesting from a commercial point of view. And this is where a customer has agreed to buy goods, but instead of the seller, the trader, just delivering those goods, the seller might arrange for a local 3D printing service to print the item in question and then to deliver it to the customer. So here, this is particularly interesting from an international sales point of view, but not exclusively in that context. But here we have a situation where the printing and delivery element is effectively outsourced to a third party. Something else that is likely to be attractive in some instances is where 3D printing could be enabled directly on the customer's premises. For instance, where there are proprietary parts which need to be supplied to a customer to use in their production process, and instead of relying on just-in-time deliveries that have to clear customs, particularly an issue, of course, for the UK now, thanks to the glorious trade and cooperation agreement that works so well. So it might be easier to have on-site 3D printing where goods which might otherwise have had to be carried by lorry across the waters could simply be printed on-site in a car factory or similar, and be used immediately for the production process of a larger item. So this is, again, a very interesting and a growing, I think, commercial application of 3D printing. These things are already starting to appear, and chances are they will grow in popularity. Obviously, always depending on the kind of products in question. Not everything will necessarily lend itself to 3D printing in quite the same way. So what then are the key issues, key legal issues, which this development might throw up? What we are seeing, I think, is a potential shift from having a straightforward bilateral contract of sale to a situation where there might be a combination of different contracts, all leading still to the creation of a finished item. We're also potentially seeing a shift in the way the production process is controlled, from effectively not having any control by the end customer to the situation where the customer can get involved in different stages of the production process. So that's a shift there. And this is the idea of unbundling, where you break down the elements involved in a contract of sale, and indeed some of the stages leading up to the contract of sale, the manufacturing stage, where you can unbundle this and allow the customer, the end buyer, to get involved much more quickly. It raises questions, of course, about how we deal with liability issues and so on, and I'll come back to those. So what we might see, first of all, is a shift from a straightforward contract of sale to separate transactions involving, say, a transaction for the acquisition of a CAD file and a subsequent transaction for the printing of the item based on the file. It raises questions about how we deal with typical sale of goods issues, say non-conformity. What if the item doesn't do what it should be doing? What if the item just isn't what was expected? And then who should be liable? In standard sales law under the Sale of Goods Act, of course, we know that liability falls on the contractual seller, and there's therefore no real question as far as the end buyer is concerned as to whether the seller is ultimately responsible, or a designer or a manufacturer, and so on. Everything is channeled through the seller as the final person supplying the goods to the buyer. But because we are unbundling the process, we now raise questions about where precisely the source of the non-conformity might be, and therefore whether this raises different liability issues. We could start with a faulty design, where the design itself wasn't carried out properly, wasn't done with sufficient care, was done incorrectly. The design itself is at fault. The CAD file as an item of digital content might be at fault. It could be a corrupt file. It could be a file that uses an unexpected file standard, file type. It could be the coding within the file that doesn't allow for easy application of the CAD file by a printer, and so on. The printer itself could be the problem. The printer itself might be faulty. The printer might not interpret the CAD file correctly. So the printer, and therefore the printer manufacturer or supplier, might be in some way responsible for the non-conformity. Similarly, there could be a problem with the materials which were used for printing, or the operation of the 3D printer and indeed the final finishing and processing of the item. So whereas in a normal contract of sale, none of these questions really concern the end buyer, these matters might suddenly start to become more significant when we are looking at an unbundled process relying on 3D printing. In particular, from the commercial sales point of view, it raises questions about how we deal with the conformity of digital content. I'll say more about this in a moment, and also potentially the liability of commercial 3D printing services. I suspect that this is probably mostly dealt with by common law and our legislation, but there is certainly a question mark on the digital content side when we are away from consumer law. So let's look at the easy case, the sale of the finished item made using 3D printing. This is my situation one. As we know, the Sale of Goods Act 1979 will apply to this because 3D printed products are still goods within the definition in section 61(1) of the Act. We don't need to expand pack this. And therefore, 3D printed items, just as items manufactured in any other way, have to correspond with the description, if sold by the description, have to be of satisfactory quality, applying our reasonable person standard. And if the item was required for a particular purpose that was made known, the item has to be reasonably fit for that purpose. Standard sale of goods fair, in other words. Problem one, the CAD file. What about the CAD file? Well, first of all, let me remind us all of the important distinction between the file itself as an item of digital content and the design, the information that file might include. This distinction seems to be significant because if the design is flawed, but the file perfectly includes the design as it was created and perfectly instructs a printer to print it, it might be difficult to argue that the CAD file itself is somehow non-conforming. The design is problematic, but not the file. And of course, the converse situation might also arise. The design is fine, but then something has happened to the file containing the relevant information. And as a result, the end product isn't what was expected. Assuming we are concerned with the file itself rather than the design, we are coming back to fairly familiar questions, which bizarrely remain somewhat unsettled even now, despite quite convincing arguments one way or another. We know that as defined in the Sale of Goods Act, software and digital content doesn't qualify because of the lack of tangibility. And as we may recall from the Computer Associates case, which wound its way through the courts not so long ago, English law does still seem to struggle a little bit, aside from the consumer law field, with the classification of software and digital content and whether or not it qualifies as goods. Of course, as far as the Computer Associates case is concerned, the Supreme Court eventually overturned the Court of Appeal by default, as it were, following the Court of Justice's ruling. And we now know that as far as the commercial agents regulations are concerned, software is included in the notion of goods in that context, but that doesn't apply to the Sale of Goods Act. Insofar as the design is problematic, of course, the design would be a service and therefore covered by the 1982 Act. So as far as the CAD file is concerned, if the file itself isn't working, and if we follow some of the reasoning that has been deployed in the case law, perhaps the Better Computers approach from 1996, treating digital content software as sui generis, might be the most appropriate way forward. It does allow us, therefore, to use the common law kind of equivalency approach to effectively require similar implied terms as we would see in the context of goods. We would, of course, then rely on standard common law remedies, damages, and or termination where appropriate. And it would be raised interesting questions about the extent to which any consequential losses would be recoverable. For example, if a CAD file is faulty, the finished item might not be as expected. That's how you would normally realize that the file is faulty, unless the printer refuses to operate altogether. And so there may be questions as to whether there ought to be compensation for not having the finished item, or indeed the cost of the printing materials and so on, whether this ought to be recoverable or not in those circumstances. It's worth noting in the consumer context, the UK's Consumer Rights Act may or may not apply because it operates with the notion of digital content, which is similar to European law. But in the recent Digital Content and Digital Services Directive, Recital 26 makes it clear that the directive is intended to the supply of electronic files required in the context of 3D printing of goods, which suggests that these files would be regarded as digital content. But of course, Recital 26 has a certain degree of circularity in it. And this is interesting because the conformity requirements in the recent European directives have been somewhat more modernized to make explicit reference to elements which are more typically associated with the digital age. So for example, functionality, compatibility, accessibility, security, and so on. So these are the kinds of things which are perhaps significant now, which would not normally be kind of immediately obvious in English law, even though they would probably also be recognized implicitly. So conformity of the 3D printer, that again still raises no major issues. The Sale of Goods Act would apply because the 3D printer is a physical item and would deal with all the issues that arise. So the printer has to be of satisfactory quality under section 14.2, applying the reasonable person test. What would a reasonable person think of the printer, bearing in mind its description, its price, any other relevant circumstances, and then the list of factors in section 14.2b. And as I've just said, those listed relevant circumstances in section 14.2b are, of course, now somewhat dated, going back to the mid-1990s. And there's a question whether these, both in the Sale of Goods Act and indeed the corresponding provisions in the Consumer Rights Act and elsewhere, might need to be updated. And of course, our 3D printer also has to be reasonably fit for any particular purpose which has been made known. What would this cover, therefore? It would cover, undoubtedly, the way the 3D printer itself performs. Does it work? Does it print something? Does it actually do what you would expect it to do? It would also extend to the ability of the 3D printer to interpret a CAD file, because without the CAD file, the printer can't do anything. So there clearly has to be some ability to interpret the file. The problem is that there isn't just one form of CAD file standard, nor one CAD file type. And there may be compatibility issues here between printers and the different CAD formats which are out there. There might also be different types of metadata in the CAD file, for example, regarding units of measurements and so on. So there may be a problem for the 3D printer to interpret all CAD file types. If that is not immediately obvious, then this could result in the printer doing something, but not what was intended, and that could create both quality issues, but also potential safety issues. The question is whether problems with the printer would then extend to the printed item if the printed item is non-conforming because of some of these shortcomings. Could you say that the fact that the printed item itself was not as expected is due to the printer, and therefore fault should effectively rest with the printer supplier? I won't say too much about the material, the filament used in the printing process, because the points made about the physical printer itself would also obviously also extend to the way the material is supplied. Let's look at 3D printing services as another ingredient. When you go to a 3D printing service with a CAD file to have it converted into a physical item, it kind of takes us back to our good old-fashioned contract of work and materials, which of course is now dealt with largely by the Supply of Goods and Services Act 1982. Creating the finished item will probably be a contract for the transfer of goods, which involves a service element. So if you look at the way the Act is designed, it has sections dealing with the transfer of goods, it has sections dealing with a service element, and a contract can effectively include both. A contract can be a transfer of goods with a service element, and a contract of service with a transfer of goods element. So each section of the Act would deal with the respective aspects of that contract. As far as the goods are concerned that are ultimately printed by a 3D printing service, they have to fulfill the same conformity requirements that we would see in a straightforward contract of sale. But there's the additional service element in that the 3D printing service is using the design supplied by the customer to convert it into a finished item. And there's a service element here, but the question is, what exactly does the service element involve? We know that the service has to be performed with reasonable care and skill, and this might extend to, for example, the right choice of materials to print the finished item. It might require some finishing work to be done to the printed item. I mentioned earlier that in the case of some types of 3D printing, a skeleton structure has to be printed that subsequently has to be removed, and therefore there will be some final finishing to be done on the item to ensure it's only the finished item. There's no remnants of the supporting skeleton or scaffolding in place. But does this obligation extend to, for example, an obligation to check whether the design is viable, whether it can be printed? Is there a duty to warn in case the item can be printed, but it might cause some risks? Or is there a duty to warn if the item could be printed, but it wouldn't be very stable? What obligations might be associated with this reasonable care and skill duty? This is going to be an interesting question, I think, and I'm sure there'll be room for debate on what exactly should be covered by this. Just let me home in on one particular example I explained earlier in situation 4, where we have a local 3D printing facility used by a seller in order to perform a contract of sale. As we know, under any sale contract, there is a delivery obligation, because ultimately the buyer wants to take delivery of the goods in most sales contracts, leaving aside commodity contracts. So if we look at the definition of delivery, it involves the voluntary transfer of possession from one person to another, section 61 of the Sale of Goods Act again. So in other words, the seller's obligations normally extend to the point where the finished printed item is handed over to the buyer. So if the seller uses a localized 3D printing service to effectively print the item in the consumer's country, if you like, and then deliver to the consumer, that is effectively done on behalf of the seller, and the seller's obligation to deliver probably is only complete once the 3D printing service has delivered those items, unless the contract is somewhat designed differently. And this means that any delays or questions of non-conformity would be a matter for the seller vis-a-vis the buyer, although the seller might have then internal recourse against the 3D printing service they engaged. One question is, what exactly though is required to fulfill a delivery obligation? What would be a voluntary transfer of possession? In particular, if it could be constructive delivery. We know this has been admitted into the Sale of Goods Act through various cases, particularly in the context of the Nemo data exceptions, but of course the delivery is used in the same way throughout the Act. So for instance, would it be sufficient if the buyer received some kind of document or even some kind of electronic key, possibly via the blockchain to make it more exciting, allowing the buyer to effectively get a 3D printing service to make the item on presentation of the document or the electronic key, in which case the delivery obligation might well be complied with much sooner than the actual delivery of the finished item. And this might create questions as to whether the liability of the seller is still extends to the printing of the item itself and the conformity of the finished item. Could certainly be an interesting question. I suspect the answer would be yes, but it's certainly something that might need to be thought about. Let me just say a few words about international commercial contracts before I wrap up. Because there are clearly attractive possibilities for the use of 3D printing in international commerce. When we look at the different aspects I identified earlier, we may have to see to what extent international sources already support the use of 3D printing. For example, how would the CISG, the UN Convention on the International Sale of Goods, 1980, be deployed in the context of software transactions? Now, the convention is concerned with goods. It doesn't contain a definition of goods. And there has certainly been an understanding and assumption amongst some courts in some contracting states that software or other digital content would be covered by the notion of goods for the purposes of the convention. And there are very good reasons why this might be so. Sarah Green wrote a very interesting piece a few years ago in the Research Handbook on International Sales. And that nicely explained why, in the absence of a definition to the contrary, a broad interpretation of goods would make perfect sense and therefore could include digital products as well. The convention extends to contracts for goods to be manufactured or produced, which could therefore also extend to contracts where a 3D printing service is engaged, unless the customer provides a substantial part of the materials necessary. Now, does that, for example, mean providing the CAD file would be covered by this derogation, that in that sense, the customer provides a substantial part of the materials necessary? Or is this particular phrase confined purely to the physical materials used in making the finished items? This is certainly a matter, again, that creates questions of interpretation. Insofar as the convention applies, it has comparable rules on conformity and delivery to the Sale of Goods Act. They're not that far apart, and therefore the similar arguments would apply here. When it comes to our situation 4 cases, localized printing or on-site printing, I suspect the main challenge will be to design appropriate contract terms that clearly allocate the different risks and responsibilities associated with that form of 3D printing. It has also been suggested that we might need to develop new model contracts. For example, it has been suggested by Greenbaum, Gelbart and Scheinberg a few years ago that we might need new types, or at least a new type of Incoterms to deal with contracts involving the delivery of products by a 3D printing process. So there might be some work to be done in order to facilitate the potential increase in the use of 3D printing internationally. There was an interesting report a few years ago, I think it was prepared by ING, and they suggested that a significant proportion of global trade could be replaced by this kind of on-site localized 3D printing instead of centralized production and container shipping. We'll have to wait and see. So let me wrap things up here so we've got time for questions and discussion. I think what I've tried to show, and hopefully I've managed to do that, is that 3D printing can have this unbundling effect on traditional supply of goods transactions. I think on the whole, the law is probably in this particular instance sufficiently robust to deal with the specific questions which arise. It just requires a slightly different analysis of the different transactions that are happening. What remains unsettled, certainly in English law, non-consumer law, is the precise treatment of digital contents, of CAD files and so on. It's kind of heading in a particular direction, but the matter remains somewhat obscure, as the Court of Appeals analysis and Computer Associates quite nicely demonstrated. So until there's greater clarity here, perhaps what is needed is more careful contract drafting, more work to be clear about how the risk needs to be allocated between the different parties, how different obligations and responsibilities need to be allocated between different parties, and so on. So I think I've probably said an awful lot in a very short space of time. I hope it's made some sense, and I look forward to questions and discussion. Thank you.